Obviously a historic day for the ECCC, hopefully for many Cambodians as well, because this is the first time that the court has reached a final judgment in, deciding criminal responsibility for some of the members of the national leadership of the Khmer Rouge. So just to summarize very briefly what was the findings of the Supreme Court chamber, because I noticed that there were some confusion among the media about what was actually decided in addition to the sentencing. The Supreme Court chamber first, they upheld the sentence of life imprisonment for Kusampan and Nunchia. They upheld the convictions against Kusampan and Nunchia with regards to the evacuation of Phnom Penh, with the exception of the crimes against humanity of extermination. And for the second population movement, which started in 1975 and went into 1977, the Supreme Court chamber upheld the conviction for crimes against humanity of other inhumane acts. They overturned the conviction on crimes against humanity of extermination. They overturned the conviction for crimes against humanity of prosecution on political grounds, and they entered a new conviction for the crimes against humanity of murder. When it comes to the convictions against Kusampan and Nunchia for the crimes committed at Tulpushray, the Supreme Court chamber reversed the conviction in its entirety. It's important to emphasize that the Supreme Court chamber did rule that there was evidence of a massacre at Tulpushray, but as was said in the summary and which is further described in the judgment, they have not been able to establish beyond reasonable doubt the individual criminal responsibility of Nunchia and Kusampan related to the killings at Tulpushray. So these were briefly the findings of the Supreme Court chamber in its appeal judgment.
Thank you, Mr. Lanswason, for summarizing the judgment for the national and international press representative, so that they understand about the sentencing decided by the Supreme Court chamber. And allow me to greet Madam Chia Liang, who is the National Co-Prosecutor of the ECCC, as well as Mr. Nicholas Komjun, who is the International Co-Prosecutor of the ECCC. And our press conference starts with the co-prosecutors. And the co-prosecutors, actually each party has 20 minutes for the press conference, and in the interest of time, I'd like to hand the floor to either national or international co-prosecutor to make a brief statement for 1 to 2 minutes, and then leave the floor for question and answer session by the national and international press representatives. I'd like to hand the floor to you. Chia Liang, thank you. And allow me to welcome both national and international press representatives. I also would like to welcome Cambodian people and the victims of the Democratic Cambodia regime. We have been waiting for over 37 years, and today is the day. Today we received the light of the justice. And our charges against the accused, and there were 5 initially, and 2 passed away. As for the 3 remaining survivors, we are successful in prosecuting them. So there is a success, a historical success for victims, either living here or abroad, because some victims have moved to live abroad. So today's justice is acceptable to those people, and that will contribute to some extent to their relief. And I'd like to actually have questions from you, so that I may answer your questions, and all your questions are welcomed. And of course, whatever I can answer, I will answer your questions. And I will also give the floor to my international colleague, whom I have been working with, to make a brief statement, and then we leave the floor also to you to put questions to you, since 20-minute time limit is not that long. Thank you. Thank you, Madam Chia Ling, for your brief statement in relation to your position and reactions to the final judgment. And now I'd like to hand the floor to Nicholas Komchun to make a 1 or 2 minute statement.
Thank you. I just want to thank all those who testified during this trial, because without them it would not have been possible. And all those victims who testified, civil parties who participated in the proceedings. They are absolutely essential for what happened. I know for many of them it was difficult to relive extremely painful periods of their lives, but their contribution is essential to reach what we've reached today. And what I hope is that this judgment and the judgment in case 2-2, which includes many more charges and many of the more serious charges of what happened during the DK regime, will provide these victims some measure of peace, some knowledge that the world has acknowledged the suffering that they went through, and that persons are responsible, criminally responsible for that. So, and I'd also like to thank the whole team at the OCP that worked on this very long trial, a lot of it for some years before I even arrived, and also during the appeal. We really appreciate all the work they put into it. And sorry, one other thank the donors of the court, because without the donors, without the financing, this court would not exist. So I think it is important to acknowledge also those that have contributed financially to set up this court through this long and very complex process in what I think is clearly the most important trial, at least since Nuremberg, involving the most horrendous crimes since the Second World War.
Thank you, Mr. Nicholas Komchun. Now it is a question and answer session, and you may put questions to the co-prosecutors. Please state your name and the press that you are representing.
We do not hear you. Say again.
Microphone is not on.
No, please. Oh. No.
Hello?
Yes.
Okay.
So the court's being dogged with accusations of political interference. Nick, do you think this is fair, and what do you make of these allegations?
Well, today,
Question by question, or we collect question first?
it's up to you.
One by one, or two or three more questions?
Check how many questions
Okay.
are out there.
Okay, ឥឡូវបាទសូមអញ្ជើញ
And let we have a few more questions, and then we will answer those questions as a group.
Erin Hanley from the Cambodia Daily. From the Phnom Penh Post. And I guess I just wanted to ask the prosecution what you thought of the reversals today. Were you disappointed, especially in relation to the Tol Potre crime site, and whether you have any thoughts on what impact that will have on victims? I also want to know about the joint criminal enterprise, the most extended and third form of that was also not considered for this case. Do you have any concerns about how that will affect the ongoing case 2-2 and later cases here at the court?
One more question. If not, then let the co-prosecutors answer the two questions first. So I'd like to hand the floor to the co-prosecutors.
Okay. Well, first of all, and I think this answers in part both questions, there were aspects of the judgment today that I was disappointed in. We made our arguments, but also we understand that we're prosecutors and they're the judges, and the judges ultimately decide. And similar to an election, sometimes you may not like the result, but if you believe in the rule of law, then you accept that institutions are independent and they may reach results that the parties, any one of the parties, is not particularly 100% pleased with. I think in the deliberations, the short summary that we read, what's clear is that the judges deliberated in great detail about the findings of fact and the applicable law to this case. Of course, I want to read the whole judgment, but the impression I have to date is the institution has something it can be proud of to show that it's a very serious institution where all parties were given extensive opportunities to make their case. Very extensive evidence was admitted, and the process reached this result, which, while I may not agree with all of the details, I think the ultimate result in a life sentence in this case is justice. As far as the joint criminal enterprise, again, while the chamber said they did not consider our appeal admissible because we had said it did not affect the judgment, it sounded like from the summary that they considered the issue and disagreed with us, finding that the pretrial chamber was correct in holding that JC3 was not part of customary international law in 1975, which is different from what other international tribunals have held. However, also in listening to the judgment, the chamber seemed to make some important holdings regarding the intent for what they call the first form of joint criminal enterprise. And I have to read the whole judgment, but I don't think the overall findings will hinder us in any way. We were not asking for that to be applied to case 2-1. We don't think it's necessary in case 2-2. We think that all of the crimes that were charged would be part of the criminal plan that was agreed upon. As for other cases, it's a bit speculative. I really don't want to go into it, especially since I haven't read the whole judgment.
I'd like to hand the floor now to Madame Chi Liang. Allow me to respond to the questions by Cambodia Daily and Phnom Penh Post regarding the political interference by the Cambodia Daily journalist As for Phnom Penh posed a question, that is for the facts that happened at Tulpu Tray and JCE 3. The Supreme Court chamber read a summary of the full judgment, and of course this is only a summary and it is not a full judgment. And that the question you raised is what was appealed to the Supreme Court chamber by the defense. And I hope you had listened to the summary of the judgment, but allow me to express our position regarding our independence. We relied on the existing law, both national and international co-prosecutors worked within the framework of the existing law, in the principle of law as well as in the agreements between the royal government of Cambodia and the United Nations. It stipulates the duties undertaken by the co-prosecutors and which groups of people that we could charge. If you refer to these laws and agreement, either in a form of book or on the website, you should know that there are only two types of people that the OCP can charge. First, those who were the senior leaders and those who were most responsible. We cannot step beyond this boundary, and if it were true, it would be rejected or dismissed by the co-investigating judges. So before we begin our prosecution, we have to refer to our limited scope. As for our independence, we also have to refer to the relevant law. If the law is so expressly stated, then we have to abide by the law. And allow me to remind you, this is a hybrid tribunal, and Cambodia itself is a civil law judiciary, and the prosecution is entirely based on the existing law, which was adopted by the National Assembly, and it went through the Senate, and then the Constitutional Council. We, the co-prosecutors, have to apply the existing laws, and that is what we do in the civil law system. We cannot say that it's because of the political interference that we fail to judge this person or that person. That is not the point. Second, in relation to our disappointment, if any, that our charge against the accused for what happened at Tulpu Chray, which was dismissed or reversed by the Supreme Court chamber. I have not read the full judgment yet because the summary is indeed very brief, and we will try to read the full judgment first, so that we can understand the reasonings behind the rejections by the Supreme Court chamber and whether it is acceptable. If they rely on the existing law, of course, we want to be disappointed because we want justice for everyone, namely justice for the victims and justice for the accused. That's what we want. We not only want justice for one side, but we want justice for both sides. So let's wait to read the full judgment, because today is only the delivery of a summary of the judgment. And the third point is in relation to JCE 3. The questions that put to my understanding is that whether this judgment in terms of JCE 3 have any impact on the ongoing trial in case 002/02. In the view of the OCP, it's not going to have any impact on the ongoing trial, because the facts within the latter segment, we have evidence beyond a reasonable doubt. And for that reason, we will show all this evidence to the trial chamber so that they can rely on it and use it as a basis for their decision. And again, this is our view based on the applicable law. And I believe it is sufficient for case 002/02, which is going to conclude very soon. And when I refer to 02/02, it means the second phase or second segment of case 002. For the co-prosecutors, there's still 4 more minutes remaining. Any further question?
3 minutes more with the co-prosecutor. Nguyện bày tí nữa bày xua từ cán.
So now there is still remaining 3 minutes, 3 more minutes if you have questions. For the national press representatives or journalists, you have any question? If you don't have any question, I'd like to ask whether Mr. Nicholas Kumchun or Madam Chi Lieng have anything else to add before we conclude our session.
Yes, I just want to remind, some people may have the question out there, okay, you have now have a life sentence affirmed. Why does case 22 matter? In my view, it still matters very, very much. The great majority of the victims of the Khmer Rouge regime were victims of crimes that are part of case 22. This includes all of the internal purges by the regime. It includes all the killings of Lon Nol officers other than at Tulpo Tre, in many other places. It includes the forced marriage of many, many tens of thousands of couples around the country, and the rape within those forced marriages. And it includes charges of genocide against 2 separate groups. So it's very important in my view that those crimes be adjudicated and be acknowledged, and that those victims see a formal process acknowledging what happened to them and the criminality of that. That a government doesn't have a right to simply kill, control the lives of its citizens in every way, and kill anyone it views as a threat.
Luật Kiểm Tiếu nơi sau pel mua đi.
And Madam Chi Lieng, you have 1 minute. Thank you. And I will actually use that 1 minute. I know that the time is limited. Again, allow me to state our position and our duties for both national and international co-prosecutors. We are the initiators of this criminal complaint, and as a result, we received a final judgment by the Supreme Court Chamber in case 02/01, as well as our previous judgment in case 001 against Kangach alias Dutch. We have endeavored to bring justice to the victims, and today's result will be favorably accepted by the victims who have been waiting for over 30 years. This is a final judgment, and it is not open to any further appeal, and that the true accused are convicted for life imprisonment. This is a historic day for this mixed tribunal, because we have achieved a great success, and that thanks to the contribution by national and international staff, as well as the financial support by the donor countries. During the Democratic Cambodia regime, we did not have any applicable law to use, we did not have any court, but now Cambodia is a state of law, and we try to eradicate impunity, so that it is shown that Cambodia is progressing in that path, and that the world itself should also follow the same path. and this is a very positive way forward. And again, I do hope that the victims would accept today's judgment, and in some way the judgment would contribute to their relief. Thank you. Thank you, Madam Chia Liang and Mr. Nicholas Komchuan for attending this press conference after the delivery of the final judgment. We now move on to the second group, and allow me to thank Mr. Komjian and Madam Chia Liang. And also I'd like to thank the working groups of the co-prosecutors. We now move to the defense teams for Nuon Chea and Kira Sampon. And since this press conference is live by Yon TV, I'd like last to again make a summary on the sentencing of Nuon Chea and Kira Sampon by the Supreme Court chamber while we are waiting for the arrival of the next party.
Okay, so to repeat the summary of the holdings of the Supreme Court chamber this morning, it was that the Supreme Court chamber upheld the life imprisonment sentence imposed by the trial chamber, but they did change, they made changes in the convictions of Nuon Chea and Khieu Samphan. Most notably, they reversed the convictions related to Tulpo Shrey, where the Supreme Court chamber found that although there was a massacre in Tulpo Shrey, there was insufficient evidence beyond reasonable doubt